Welcome back to the Emily Show. Quick programming note. Remember, the Karen Read trial is starting this week. If you are looking for daily breakdowns of what's going on in court and don't have time for all day, every day in court, there will be case briefs up on the Emily Show channel and on the Emily Show audio feed, so you can check that out. And if you don't want to miss a thing and need to be able to opt in quickly to trial coverage that you can catch, or the case briefs day by day so that you can keep in the loop when you can't catch the full days, the LawNerd app at lawnerd.app.com will keep you in the loop with everything. Yes, we're going to be sending notifications as different witnesses take the stand. Yes, we will send a notification when opening statements are actually starting, because you know that opening statements on Tuesday, there's going to be all of the jury instructions that happen. There is going to be fighting with the lawyers over what can be said in opening. There's already new motions today about it. So when will opening statements start on Tuesday? Probably a few hours into whatever stream we have on Tuesday. So if that's the part you want to tune in for, I will send you a LawNerd app alert so you know what's going on. But today, Diddy's been denied by the court in a way that actually really surprised me, which in the Diddy case, things have pretty much gone along where I'm like, oh yeah, that makes sense. This one I was like, oh really? Damn. There's a lot going on with the Menendez Brothers resentencing, and I bet you have some questions about it. Hopefully I have some answers. And of course, the Karen Read trial is starting, and a really surprising motion from Donna Adelson. So we're going to talk about that too. But today, I'm going to be trying to keep it brief. So good luck to me, and let's get into it. I'm legal analyst Emily D. Baker, yes, also a lawyer, and this is The Emily Show. I break down the pop culture, entertainment, and high-profile cases that we're all talking about. I know you want the facts, so let's get into it. You know I love working with companies whose products make your life easier, and OneSkin absolutely does that for your skincare routine. The all-woman led and founded team at OneSkin has focused on skin longevity so that you have healthier looking skin with a less complicated skincare routine. You literally can just wash your face, use your OneSkin moisturizer, and be done. But the topical supplement moisturizer can also work with any of these skincare items that you love in your routine, so you don't have to yeet what you already have. I love how easy OneSkin is to use. I love that I use it twice a day, and it just keeps my skin feeling good. And I know it has the anti-aging that at this age I absolutely want, because I don't mind aging. I just would like to do it gracefully. OneSkin is the world's first skin longevity company, and by focusing on the cellular aspects of aging, OneSkin keeps your skin looking and acting younger for longer. For a limited time, you can try OneSkin for 15% off using code LawNerd at oneskin.co. That's 15% off at oneskin.co with code LawNerd. And after your purchase, they'll ask how you heard about them. Please let them know it was the Emily Show, and get ready to give your skin the scientifically proven gentle care that it deserves. And your counters aren't going to be covered with stuff that you're not going to remember to use anyway. Keep it simple with OneSkin. Let's get back to today's episode. The Karen Read trial will be starting with opening statements on Tuesday, April 22nd. It's about a week ahead of where they thought they would be because the court had told the defense attorneys they could have some time to wait for the First Circuit to rule. The First Circuit ruled really quickly in denying Karen Read's appeal to them regarding the double jeopardy that Karen Read's defense team has now petitioned the U.S. Supreme Court for. I talked about that last time. They're not going to stay the case. They may not take the case. They may. It's getting conferenced. We will see what happens down the road. But trial is officially getting underway, though they've been in jury selection, with those opening statements. And now the fight over opening statements ensues, because we've got this new motion from the Commonwealth, and I am sure between the time that I record this, the time it goes live, and the weekend, that there will be more. So I'm sure by Tuesday I will be giving you an update of other things that have been filed. That's not uncommon on the precipice of trial, especially in a retrial. The attorneys can anticipate one another's moves a little bit better because they've had an entire trial to go through together. Even though some of the attorneys are new this time, you can still go and rewatch the trial. And just to highlight the point, Special Prosecutor Hank Brennan on April 17th filed this: the Commonwealth's motion regarding the defense opening statement. Your Honor. No, that's not how it starts, but that's how it starts in my head. The Commonwealth moves for an order that the defense counsel refrain from claiming in their opening statement that any of the victim's injuries were caused by any person or animal that was inside the home at 34 Fairview Road. Based on the defense request to show the abrasions on the victim's arm in opening statement, the Commonwealth notes that the court has ruled the defense is precluded from mentioning any reference to third-party culprit claims prior to establishing a viable basis, supported by admissible evidence, and any mention of third-party culprit claims relative to the abrasions would be improper. So he's trying to block any conversation about whether or not the injury to John O'Keefe's arm were caused by an animal. It was in the defense opening statements in the first trial, and the prosecution is trying to connect any conversation about the injury to the victim's arm from a dog vis-a-vis a car to the third-party culprit defense. So they are trying to necessarily lump those two together, and the Commonwealth is trying to say, if we're not opening into a third-party culprit defense, remember that's just saying Karen Read didn't do it, this specific other person did. They are trying to say, if we're not there yet where a third-party culprit defense can be given a jury instruction and it's been proven enough to come in, then you can't get into the injury to the arm. I think the defense can get into it because they have experts coming in and it goes to their argument against the state's theory of the case. I don't see that the court's going to say, no, the defense can't say the evidence will show, our experts will testify that the injuries to John O'Keefe's arm were not caused by a vehicle like the Commonwealth says, they were caused by a dog. Do I think they can say that dog was Chloe? No. Do I think they're going to try to? No. Can they say the evidence will show that the owners of 34 Fairview at the time had a dog? I think that they can. The evidence is going to show all of that. I don't think the injuries to the arm are part of the third-party culprit defense. We'll see what the court says, but I think limiting this line in the defense opening is going to be tenuous, and I don't think it's third-party culprit. I don't think they can get up an opening and say, the evidence will show, give a person's name, did this thing, but I think they can say, the evidence will show that this was not a thorough investigation, that these injuries are not from a car, and that law enforcement should have followed up on those leads. I don't see the court holding that back. But at least now we know what the one picture the defense wants to show an opening is. And remember, the Commonwealth is going to be showing clips of Karen Read's media interviews. It's going to be a very different opening statement this time. So tune in with me on Tuesday for that. We need to talk about other cases in court, though. I have seen lots of questions about what's going on with the Menendez Brothers resentencing. You might remember this case. Lyle and Eric Menendez, who are often referred to as the Menendez Brothers, collectively were convicted of the August 20th, 1989 murder of their parents. They were first tried in 1993. There were two juries at that trial, one for each of the brothers. Both juries were unable to render a verdict. The cases were declared mistrials. They went back to trial starting in October of 1995 and were convicted by a single jury in 1996. Since that time, there have been docuseries and books and conversation about this case pretty much ongoing. And the case is back in the news because the former district attorney of Los Angeles had filed a motion to consider resentencing under some new laws. And I broke that down in a previous episode of The Emily Show. That had gotten delayed due to the election of a new DA. They had gotten delayed again because of the wildfires, and then they went to court for what was supposed to be a 2-day hearing on the resentencing. The first day of the hearing on Wednesday was the district attorney's office arguing to withdraw the motion for resentencing that the district attorney's office had previously filed. I don't love when you have a political change of hands and you start seeing cases handled differently. We saw this really notably in the Bill Cosby case, where the offer made by a prior DA's office and the agreement made by a prior elected DA was held to the newer DAs. I think there needs to be consistency. I think having the elected DA be a political position puts you in jeopardy of having some inconsistency, but you can't have somebody come in and say, oh, well, we asked for a resentencing and now we can't. And that's exactly what the judge said. You filed this motion for reconsideration. You cannot withdraw it at this point. You can argue against it if you want to, but you can't withdraw the motion. I think there has to be consistency even when the head of the office changes hands. And the court agreed with me and said, no, you can't withdraw this. We're going forward on a resentencing hearing and you can argue against the resentencing, but we're not withdrawing the motion. So the hearing continued on Thursday, April 17th, and then everything went off the rails. The defense headed by Mark Garrigus, is asking to recuse the entire LA DA's office from arguing this. And the DA's office is arguing that a newly completed parole board risk assessment should come into evidence. The defense is pushing back on that, but the court is going to consider whether or not the new parole board risk assessment is to be considered in this resentencing. The parole board risk assessment was not done as part of this resentencing. It's done as part of the clemency request to Governor Newsom. So the parole board risk assessment is done separately. I have to wonder, and this is not a document I have seen or I have, but I have to wonder with how much the DA's office is pushing for it, knowing that their position is that this shouldn't be resentenced, how much the defense is pushing against it, if that risk assessment is not favorable. That is my supposition, and the court has now delayed the resentencing until May 9th, and the court is going to first consider the defense motion to recuse the DA and whether or not that risk assessment is proper evidence for the resentencing hearing. And the defense wants to bring in more than 10 family members and witnesses on behalf of the Menendez brothers regarding the resentencing. And again, I will list down below the episode where I broke down the law that has shifted to allow this resentencing. If they are resentenced under that law, they would become immediately eligible for parole, which is why the defense is pushing forward for this so much. But in the meantime, there's more. The defense also filed a motion with the court, a very strongly worded motion with the court, based on the DA's office presentation of evidence in court before the entire hearing got paused. Things have gotten very heated with the defense and the prosecution, and the defense is alleging that the prosecution failed to abide by Marsy's law, which is the victims' rights law in California, when they were showing crime scene photos in court without giving any of the Menendez family members, a lot of who are also family members of the victims in this case, any heads up that graphic photos would be shown in court. The defense is arguing that that led to one of the family members, who is 89 years old, ending up in the hospital some 30 hours after that happened. So the media has gotten this a bit wrong, saying that the DA's office is being sued over this. They're not, but there is a motion pending in court for sanction and to force the DA's office to give the family a heads up if they need to step out, which I think is appropriate as well. If you are showing images in court that can be seen by the gallery, then the members of the victim's family in the gallery have the right to a heads up. The defense is saying that that heads up was not given. We have not seen a response from the DA's office regarding that yet, so I am waiting to see that response. But that is what the defense is alleging, that the family was not given a heads up. In court, defense attorney Mark Garrigus called the prosecution's attempt a quote-unquote dog and pony show, and the prosecution apparently shot back, according to ABC News, saying Garrigos's comments were degrading. Garrigos apparently responded, "You should be degraded." I imagine that the judge at this point was like, I need all of you to stop. It's reported that the judge said he needed more information about the risk assessment report and how it can be used by the court, saying, because this is stupid. I imagine by the time the judge got to "this is stupid," he was referring to the attorneys sniping at one another in court. But that's the reporting coming out of court, and we're not done yet. ABC goes on to say that in the DA's 3-hour argument last week, he argued that the brothers who were listening to the hearing via video hadn't taken responsibility for their actions, and he called their claims of self-defense part of a litany of quote-unquote lies. The elected DA Hochman also dismissed the brothers' claims that they were sexually abused by their father. Part of the problem in this case is the distance in time. That is a big part of what the DA's office is arguing, because it was removed in time from when they are alleging the abuse. But that really rankled Mark Garrigus, who said that the elected DA Hochman was a 90s Neanderthal by refusing to believe the brothers. So none of this is going to go well in court because it has gotten so heated. And the attorney representing the brothers is Mark Garrigus. The attorney representing the family members who filed the motion against the DA's office is Brian Friedman. Yes, the same Brian Friedman that is representing Justin Baldoni and all of the Wayfarer parties in the Lively Baldoni lawsuits, which we will get back to, but their filings have been substantial and there is so much going to trial so much faster, including Diddy. Shock me, shock me, shock me with this court ruling in the Diddy case.
Shock me, shock me, shock me with that deviant behavior.
That is so clever. I swear to God, you get smarter the shorter your skirt gets.
Diddy was back in court on April 18th and with a new attorney who's someone you may know, but we'll get to that in just a minute. In court today, not only did the court rule on that Warner's Brother motion that I talked about last week, where Warner Brothers was asking the court to quash a subpoena, asking for the uncut footage of two individuals who may be witnesses. The court denied that and said, no, it is only looking for the essentially unaired footage of interviews of individuals who will be called to testify. So the reporter's privilege is overcome as to those two interviews only. And the court denied Warner Brothers' motion and told Warner Brothers to turn that over. And they said they would by the end of next week, which is, as this is airing, this week. So that's getting turned over. The court also said that memoir drafts from victim one have to be turned over to Diddy because they may relate to time spent with Diddy. So the drafts of an unpublished memoir from victim one are also getting turned over to Diddy. The court also granted the government's motion to allow victims 2, 3, and 4 to proceed under pseudonyms, and interestingly cited the Raniere Nexium cases in saying that victims could testify under pseudonyms. Remember, this is the public testimony. The defense will still have that information to do their discovery. The identity of the accuser is still known to the defense, but when they testify in court, they will be able to testify under pseudonyms. But court is still open, so I hope that as the media goes into court and watches, they will abide by the pseudonyms. I think that they should, even if the individuals are recognizable by face, even if they don't give their name. I think it's appropriate to not have that in the media once the court has granted that order, and they did, as to those victims. Remember, there are now more victims because Diddy had a superseding indictment. That fourth superseding indictment I previously spoke about added additional victims. And because of that fourth superseding indictment, Diddy's team asked for a 2-month continuance or adjournment, as they call it in New York, of the case. And they wanted to adjourn the case for originally 2 weeks, then 2 months, saying that the additional counts and additional victims required more time. And I looked at that and went, well, this case has been a rocket ship to trial. It's been moving faster than I ever anticipated. I thought that this case would get continued. I've said this the entire time, and shock me, the court was like, denied. Denied. Motion for continuance, denied. The court said 2 months is too much time, and so the motion for the delay is denied. That the fourth indictment covers behavior that was already largely outlined in the other indictments in the RICO charges, and therefore they don't believe the defense needs another 2 months. The court also said defendant has 4 law firms working on this. Emily, 4 law firms? Yes, 4, because he added a new one. Remember, Diddy did lose an attorney a while back, and I covered that, but he added another one and another one. Well, this was filed April 16th, 2025. Motion for admission pro hoc vice. Remember, that means I don't practice in this state, but can I please practice here for just this case? Well, attorney Brian Steele hereby moves this court for an order of admission to practice pro hoc vice and appear as counsel for Sean Combs' defendant. Remember, you might know the name Brian Steele from the YSL Young Thug RICO prosecution in Georgia. So Brian Steele has now been added to Diddy's defense team. What I thought was really funny is that Brian Steele had to line out that he was held in contempt in June 2024, where the judge wrongfully ordered that he reveal privileged information. The misdemeanor contempt conviction was reversed by a unanimous Supreme Court in Georgia on October 22nd, 2025. And then he included his Supreme Court of Georgia order of good standing. So he had to disclose all of the nonsense that went down in Georgia, where the judge is like, disclose privileged information. And he's like, yeah, put me in jail. I'm not doing that. And is now on the Diddy defense team. It's a good time to remember that all criminal defendants, no matter how much their behavior is wild, they are accusations They are innocent until proven guilty, and defense attorneys will take clients of all different levels of public empathy, sympathy, and popularity. So I am not surprised that Diddy's team reached out to Brian Steele and said, you fought a large RICO case in Georgia. We need you on this team. And it does not surprise me that Brian Steele, as a defense attorney, was like, let me see what I can do on this team if the money is right, because that is a part of it. So Brian Steele is now part of the Diddy defense team, and I am very interested to see how that goes. Also, back in the news is Donna Adelson. Donna Adelson is going to trial in June. We'll see how that goes. Her trial date is set to begin jury selection June 3rd through June 9th, and then start trial. By all reasonable possibility, I will still be covering the Karen Reed case, and we will see what happens with the Adelson case, but she made 2 motions to recuse the judge, and they were immediately denied. Judge Everett was like, ma'am, do not try me. This case was supposed to start last September and didn't. We'll see what happens. But Judge Everett's like, we're not recusing Judge Everett off of this case. Not a chance. So everything looks slated to go forward. There's a final conference on May 16th. I'm going to be keeping a close eye on what happens there. And finally, a lot of you have been asking me about what the heck is going on with Tom Girardi. Well, I understand why, because his CFO that had, remember that side fraud of Tom Girardi's fraud where he was convicted of stealing from clients. Tom Girardi's CFO, who was a part of that side fraud, was just convicted to 10 years. And that is for the more accomplice fraud, though it wasn't charged that way. So the question is, Tom Girardi was convicted like last year, towards the end of the year, but why hasn't he been sentenced yet? Remember, he was sent out for an evaluation to see, based on his age and mental capacity, whether or not he would be sentenced to prison or sentenced to some type of an appropriate facility. And this case continues to be continued for that determination. On April 4th, the attorneys stipulated that Tom Girardi's hearing that was set on March 18th for April 11th would be continued because they still need time to decide whether or not Mr. Girardi should be committed to a suitable facility in lieu of imprisonment. They're going to bring in witnesses and testimony for that, and it is continued at this point to May 8th, 2025. So whether or not Tom Girardi is going to prison and how long his sentence will be is still being determined, and we won't know until, well, after May 8th if that hearing goes forward that day, but experts have been evaluating Tom Girardi. He was sent out of state to have evaluations done to determine what housing situation would be appropriate for him due to, again, age and mental capacity. So with all of that, Diddy's continuance got denied, which is wild. So he's supposed to be starting trial at the beginning of May. Donna Adelson looks like she's starting trial at the beginning of June, and the summer of trials is just not going to stop. Remember, the Diddy case is not going to be televised. It is going to only be reported from those that are present in court. I imagine the court will do a lottery of media outlets that are certified through the Southern District of New York. We will see how that's going to operate as we get closer to trial, or if he'll try to get a continuance at least of a couple weeks again. I suspect that he will. Donna Adelson's going to trial. Karen Reed's going to trial tomorrow. And there's going to be more happening in the Kohberger case as we're waiting on rulings. And of course, the Lively Baldoni case, but the lawyers have filed like 17 novels. Right now, we're longer than the Throne of Glass series, I think. So it's a lot of reading that I need to catch up on. And with that, thank you for being here. Thank you for being a Law Nerd. I will see you in the Law Nerd app at lawnerdapp.com so you stay in the loop with all of the trial stuff that you want to see. And I will see you in the comments in the case briefs to answer any questions you have about the day today. But if you want your answers in real time, you just need to be in the chat. The Law Nerd chat is the best place to watch trial because the Law Nerds are here for it. They're here for the facts. They're here for the good lawyering. They're here to have conversations without the fuckery. Though I will say sometimes we do get up to a little bit of nonsense. It's normally related to those that we adore. So with all of that, I hope to see you in the chat for the Karen Reed case, and I will see you in the next episode of The Emily Show. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a law nerd.